So a lot of people are asking, what happened to custody now that we have allocation of parental responsibilities? The reality is custody is allocation of parental responsibilities. In other words, people used to fight over custody all the time and didn't really understand what it meant. People would come into my office saying, I want sole custody, split custody, joint custody. And when I'd ask them, what does that mean to them? They didn't really know. Sometimes people would say, well, I was told I need to fight for it. The reality is this. Custody has always been about decision making. We've made it simpler by saying allocation of parental responsibilities. It's a longer phrase, but it's a simpler process because now we have 4 things that we're focused on. That's education, religion, healthcare, and extracurricular activities. We focus on those decisions. How do those decisions get made? Who makes the decisions? And what is the process going to look like? So it's really important to understand allocation of parental responsibilities and parenting time are not the same thing. The best way I explain it is a parenting plan is the comprehensive document, the comprehensive goal of a situation. That breaks down into 2 components. That's your allocation, your decision making, and then your parenting time, which then gets broken down into 3 sections, which is your regular time, your breaks, and your holidays. When it comes to custody arrangements in Illinois, we don't technically use the word custody, but really what it comes down to would be either a sole or a joint situation, meaning one parent makes the decisions or both parents make the decisions. When you have a joint situation, that means the parents work together and come up with a decision on a situation by situation basis. For example, if parents have joint healthcare decisions, that means if something comes up with one of their children, they're going to work together on making that decision. For example, maybe they go and speak to the pediatrician and they follow their advice. If one parent doesn't like it, they might seek a second opinion before having that final decision made. Now, if you have joint decisions, you still got to come to an ultimate agreement. If you can't, typically you're going to go to mediation afterwards. And if you still can't resolve it, you're ultimately going to have to go back to the court and have the court make a decision, or really have the court decide which parent makes that decision. Now, if you have sole decision making, that means you don't go through that process. One parent just simply makes the decisions and the other parent has to live with it. Usually this doesn't happen, but that's the difference between sole and joint. So often people ask, is there a mother's rights, a father's rights, joint? And candidly, people have all types of opinions about that. Illinois does not have a standard that they fall into automatically saying joint, or that they have a default to joint or default to mom or default to dad. The reality is they are decided on a case-by-case basis. Now, that's what the law says. There's also some practicalities. Your judge is going to make a huge difference in this. The adverse party, their attorneys, your attorney, that's going to make a huge difference in how this situation comes out. But by default, there's no automatic joint or automatic sole. So what does the best interest of the child standard mean? It's kind of a long-winded phrase, but essentially what that means is when we come up with the decisions, when we come up with the plan, the judgment, the things that we put in writing for your kids, we're looking at a variety of different factors. Ultimately, when it comes down to it, if the parties cannot agree, the judge will have to make a decision. The judge is going to have to look at those factors. They're going to have to say, what makes sense for this child under these circumstances, and ultimately those factors will guide what that ultimate outcome looks like.